right is still right, even if you stand by yourself.
Mr. Chief Justice, may it please the court.
Welcome to this week's edition of Case in Point, the legal show for regular people. It is Thursday, January 30th. I am your host, Sarah Pershall-Perry, a senior legal fellow here at the Heritage Foundation in Washington, D.C. And it has been a flurry of activity in the nation's capital in the past few days. We've seen 3,500 ICE arrests, more than 300 executive orders, an official recognition of a two-sex government policy, male and female, and an end to all diversity, equity, and inclusion programs funded and through the federal government. Conservatives everywhere are celebrating a lot of what they consider to be significant wins, but one executive order in particular, ending so-called birthright citizenship, has proven to be controversial not just in conservative circles, but in liberal circles as well. Where does this so-called birthright citizenship right come from? Well, from the 14th Amendment. But what did the ratifiers and framers of the 14th Amendment mean when they included language on citizens of the United States? We're going to talk to senior legal fellow Amy Swearer, who wrote a substantial law review article on exactly that definition here on today's Case in Point, and discuss whether or not Trump's executive order is going to stand up in court. So with that, we bring you this week's Case in Point. I am joined by my dear friend, and I know I say that about everybody that
we actually are friends.
We are actually real life IRL. We are friends. Senior legal fellow Amy Swearer, who covers quite a number of different issues for us in the Meese Legal Center. But she joins me today because she just published a really important law review article. It is very substantial, very long, very well researched, and she is probably one of the best people in the country to talk about what we're going to talk about today, which is the executive order that Trump issued ending so-called birthright citizenship. This has proven to be very controversial, even in conservative and liberal legal scholarship spheres, and even all conservatives don't necessarily agree on it. And what we're going to talk about today is the research that you've done, which is, it's incredible, it's unassailable, but it proves why something like ending birthright citizenship, or what we've understood to be birthright citizenship, should come to an end. 22 states' attorney generals have already sued, saying, this is absolutely illegal. So let's talk about it. I want to start with, what is birthright citizenship?
Sure. So what are we actually arguing about when we say that we're arguing about ending birthright citizenship? Because I think this is important. Because when you say, we're just ending birthright citizenship, that makes it seem like it's this argument that no one born in the U.S. is a citizen by birth, which is not the case.
Right.
What we're arguing about is the meaning of the 14th Amendment, right? Which says that all persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens.
Right.
And what we're really arguing about is this phrase subject to the jurisdiction thereof. What does it mean, right? Because on one side, you have what I'd consider probably for the last 80 to 100 years is this widely held understanding and interpretation, and certainly how our government has treated it during that time, that it basically means everyone, right? That it's almost redundant. The only thing that excludes, the only people who are not subject to the jurisdiction of the United States under the Citizenship Clause are the children of accredited foreign ambassadors and foreign diplomats. In many respects, that we just sort of adopted this older English common law rule that basically everybody born here is a citizen no matter what. That's contrasted with not just my view, but what I would consider the original public meaning of that phrase, what the men who drafted and ratified the Constitution and what subsequent generations, those earliest generations of American legal scholars after that understood, which is that it's far more limited, right? That not everyone is subject to the jurisdiction of the United States, but that this is a phrase closely associated, that basically is encompassing this understanding of people who are sufficiently part of the American body politic, right? That they are part of the American people, that they are fully and completely subject to our jurisdiction, as opposed to still being subject to a foreign power, still being meaningfully tied,
a citizen.
Right?
Yeah,
well, right,
of another nation,
right. That they don't owe this significant allegiance to a foreign power. That they understood it as being much more limited, right? So I think this argument can actually better be framed, be better framed as not between birthright citizenship and not birthright citizenship, because everybody agrees there is some level of birthright citizenship guaranteed by the Constitution. But we're talking about whether it is universal or whether it is more limited. And allegiance based.
Okay, so it really comes down to that phrase that you just emphasized, subject to the jurisdiction thereof. So let's talk a little bit about, and we've mentioned the term originalism on this show. We want to know what the ordinary, plain, accepted meaning of a term was. At the time, the ratifiers of these constitutional amendments actually drafted them, and then we look at what the Supreme Court's actually articulated are additional factors like history and tradition. And boy, did you dig into the history on this. I mean, to the point where I don't know anyone who knows the history the way you know the history. So bring us kind of up to speed on exactly what the history meant when they were ratifying the 14th Amendment and writing that particular clause.
Yeah, so let's take sort of a giant step back conceptually, right? So at the beginning of this nation's history, right, and under the original Constitution, the Constitution talks about citizens, but it never defines that term. It never tells us this person is a citizen and this person isn't. It says Congress can naturalize people, it can pass laws, but it never defines that, and Congress never really defines that. And so you sort of start to see development, and this is basically the argument, by the way, from universal birthright citizenship advocates, right? Is they'll say, well, in the interim, we needed some way of defining citizenship, and scholars and courts at the time just basically adopted and took on as their own the English common law definition, right? We just sort of kept that and applied that. In this English common law understanding of citizenship, it's also known as jus soli, and it's this concept of it comes from feudalism, right? So basically, you are born owing a natural and an unseverable allegiance to the government under which you're born. Right?
Okay.
So basically, if you are born in a place, you're born a subject, not a citizen. You're born a subject of that government, and you owe natural and perpetual allegiance to that government. You can't leave that nation and go to another nation and swear allegiance to another sovereign. And if you try to, it doesn't count, right? You are always subject to that sovereign under which you're born. Very feudalistic.
Okay.
Right? And what advocates of universal birthright citizenship say, right, is that is sort of what gets adopted in the United States.
Right. So in other words, if your parents are illegal immigrants, but you have a child that's born here.
We're talking about like prior to the 14th Amendment, right?
Right.
And then what happens is we get to this case called Dred Scott v. Sanford, right? A big case in 1856, right? Where the Supreme Court is asked to decide, basically, does this apply to African descendants of African slaves, right? And the Supreme Court in Dred Scott v. Sanford says, no, we didn't adopt this common law just solely, and if we did, it certainly doesn't apply to African descendants, right? Basically, if you were a descendant of slaves, if you're not a white European descendant, this country wasn't for you. Citizenship isn't for you. You aren't a citizen. You can never be a citizen, right?
Right.
And on this, we agree, right? That is what Dred Scott stands for. Well, a couple years later, right, we have the Civil War. We pass the 13th Amendment. We ratify the 13th Amendment. Slavery is no more. But Congress is left to deal with, well, we have a Supreme Court that said essentially non-white residents can never be citizens.
Yeah.
Right. We have generations of black Americans who are not really Americans, right? Are we really going to say, there's one congressman in particular, right? He's like, are we really going to say that they can commit treason 5 generations later against some African potentate that none of them have ever been subject to, right? And so Congress has to deal with this question of how do we affirmatively make them citizens? How do we undo Dred Scott, override Dred Scott, and make this entire segment of the population citizens unequivocally? Right? And we all sort of agree on that history. Where we start to disagree is how Congress does this, right? So again, advocates of universal birthright citizenship will say that Congress overrides Dred Scott by just statutorily and then constitutionally adopting the English common law. Right? Say, we're undoing this and we're going back to this English common law. But I think when you look at what Congress has to say for itself, when they explain for posterity what they're doing, and then how that generation of legal scholars understood those words to mean, and when you put it in its full context, that's not at all what they're doing. So first of all, I would actually take issue with this idea that the United States, after the Revolution, just sort of full-scale adopts English common law just solely. First of all, that is incompatible with the foundations of the Revolution.
American Revolution itself.
The whole idea is that we're actually not perpetually in allegiance to the sovereign under which we're born. We can sever those ties. We did sever those ties. And actually, the way government ought to work and does work, that we say it works in this country, is this idea of compact, of the consent of the governed. Right? That you can expatriate, you can choose allegiance to a foreign power, and that when the people create that compact, right, you also can't just unilaterally come in and say, yeah, I'm part of that too, right? They have to agree that you can come in. And once they agree that you can come in, right, you can't actually say, well, I'm joining these guys now. That's where my allegiance is. Right. So I actually don't think it's the case. And you see this even in like Joseph Story, right, who universal birthright advocates like to point to. You see some of this sort of Americanization of the common law, even with respect to things that are perpetual allegiance, that are really about who is a citizen. In Birthright Citizenship, this Americanized version, he says, not in his commentaries on the Constitution, but in 1834, his on the conflict of laws. He actually has an asterisk in there when he's talking about pre-14th Amendment common law citizenship in the United States. He says, well, it would seem like a reasonable qualification that this doesn't apply to persons who are only here temporarily, who are in itinerary, right? Who are only here traveling for business and temporary reasons, right? So even there, you start to see this Americanization of this. And this is really clear and evident by the time you get to where Congress is talking about statutorily and then constitutionally defining citizenship, right? And again, I'm getting a little into the weeds here, and I know this. But when you look at the years leading up to the 14th Amendment, this country is in a war where Congress is having to very seriously and directly wrestle with this question of who is sufficiently ours. In this nation of immigrants. Who is sufficiently ours that even if they haven't naturalized yet, we can force them to fight in this war, right? That we can include them in the Enrollment Acts, and we can compel them to take up arms for this nation. And they're having very serious debates over this because you have countries like France, Germany, the UK, right, who are sitting there going, well, you can't compel our subjects to fight, right? They may have been resident in the United States for a long time, but you can't. They're still ours. Because of perpetual allegiance. And Congress is wrestling with this, and the fight and the way that they draw this line in the Enrollment Acts. And these are the same senators that are a couple of years later going to be talking about citizenship and defining it in the 14th Amendment. The lines that they draw are to essentially say, well, we can draft citizens and we can draft foreign-born immigrants who have filed what was known as their Declaration of Intent. So up until really like 1952, the way that you became a citizen in this country is you came over and you filed two sets of papers. So your first was called a declaration of intent. You went down to the courthouse and you swore under oath that you intended to become a loyal U.S. citizen, and you intended to sever all ties of allegiance to any foreign power, right? Then you had to reside here a certain amount of time, and then you file your naturalization papers. And so when Congress is talking about, well, who can we draft?
Yeah. Into this civil war.
And they say, well, the people who are not sufficiently subject to any foreign power, that the foreign power can say, hey, those are our guys. Those are our subjects. It's the people who file their declaration of intent, right? And the only argument outside of that is, well, what about the people who haven't filed the declaration of intent but have lived here long enough that at the time some states actually allowed them to vote, even though they weren't naturalized and hadn't filed that declaration of intent, or to even hold public office. Yeah. And so the fight is, well, if these guys are sufficiently subject to our jurisdiction, right, that they can't simultaneously say, well, we are going to exercise our right of suffrage in this nation. We're going to be part of the American body politic.
Right.
But we're still subject to the foreign power so that you can't draft us.
Right. Exactly.
We're like Americans so we can vote, but like French so we don't have to die. Right.
Yeah, and what a strangely applicable argument to where we are in the present day. When we're talking about things like illegal immigration, we're talking about tax benefits and jobs and free education and free health care. It's very similar to this.
Exactly. And so this is very real for these members of Congress who are struggling with this. And this is the context into which they're now coming in to this question of how do we define citizenship, right? They've already fought for years over this conception of who is subject to a foreign power, who's not, right? This isn't happening in a vacuum. So when the first act of Congress to try to undo Dred Scott is actually not the 14th Amendment.
Right.
It's the Civil Rights Act of 1866. And this is part of the equation that I think a lot of modern universalist advocates sort of skip over. So Congress in 1866, they try to undo Dred Scott statutorily. And the definition, it's the first time in American history that we at all define birthright citizenship and its parameters. And it doesn't just say, well, everyone born here is a citizen. It doesn't say, well, we're adopting common law just solely. Congress says in that first attempt that citizenship, birthright citizenship, belongs to those who are born here, not subject to any foreign power, and also excluding including Indians who are not taxed, right? Which is a term of art, right, that we don't have to really get into.
Very interesting and very specific turn of phrase in 1866 in the first Civil Rights Act.
Of saying you can't be subject to a foreign power.
Right.
Now, what does that mean? Right? Because in a vacuum, that sounds ambiguous. We don't have to guess. They tell us explicitly what they mean by this and how they got to this. So Senator Lyman Trumbull, who is not just some Yahoo play acting at constitutional scholarship here. He's a very serious legal guy, right? So prior to joining the Senate, he was Secretary of State for Illinois. He served on the Illinois Supreme Court for, I think, like 6 or 7 years. He had actually, at one point, successfully argued a case in Illinois that resulted in slavery being de facto banned in that state.
Wow.
Very serious legal guy. He's heavily involved in drafting this language. And he, at one point in the legislative history, starts recounting for his fellow senators, hey, guys, here's how we got to this language. And I'm going to pull this up because I want to quote this verbatim.
Yeah, please.
So he's recounting sort of the development of this language and how they've been playing with it. And he actually explains to them, hey, one of the problems that we've been having with this language is essentially like how best to exclude certain people. Yeah. So he says there's certain people that we can't make citizens of. So he says there's difficulty in framing the amendment. So this is the amendment concerning the Act's citizenship clause, right? So as to make citizens of all people born in the United States and who owe allegiance to it. I thought that might perhaps the best form of which to put in at one time might be that all persons born in the United States and owing allegiance thereto are declared to be citizens. But upon investigation, it was found that a sort of allegiance was due to the country from persons temporarily resident in whom we would have no right to make citizens, and that form would not answer. In other words, he says, hey, look, our first attempt was to just say, were you born here and owing allegiance?
Right.
And then someone pointed out, well, that's going to make citizens of like the U.S.-born children of people who are only here temporarily.
Sure. Whether it's medical care or they're passing through.
And he's referring to the common law.
Sure,
right?
sure.
That someone points out to him, hey, under the common law, that might plausibly make them citizens. And he's like, oh, no, we're not going to do that.
Yeah.
Right? They're very clear. And what's, I think, even more important there is it's showing his conception, as a legal scholar at the time, his conception of citizenship. He's not thinking about it. When he's coming up with these words and like allegiance, and his conception of that is not English common law allegiance.
Right.
And it is so much not his conception of citizenship that someone else has to point out to him, hey, other people might mistake that as you meaning this English common law citizenship. And he goes, oh, thank you. Yeah, that's not what we're doing. And so they go through several iterations of this, where they get to the final language of not subject to any foreign power. And it's clear like that's not what they mean. They mean this broader conception of what they were talking about during the draft, right? Of who has sufficiently become part of the American body politic.
Right.
That we can, they're sufficiently like citizens that we can send them forcibly off to fight and die for this country, right? And I think that's pretty clear. And that is just indicative of, I think, many times throughout the debates where they make it clear, right? They mean not subject to a foreign power as sort of the same thing as like owing full allegiance to this country. You've sufficiently become a member of the body politic.
So you've anticipated a little bit of my devil's advocate argument, which I think is where you're going next, which is the language in 1866 was different than the language in the 14th Amendment in 1868 in the Citizenship Clause. So why not just adopt what was previously working in 1866?
Yeah, and this, you're right. This becomes the argument or the counter argument, if you will, even amongst conservatives who, when people do bother to mention the Civil Rights Act, the common argument is, well, the 14th Amendment abrogated that, right? If Congress wanted to use that same language, it could have, but it didn't. So clearly they were trying to just use this broader conception. But that's, I think, again, not warranted from the history itself. You see throughout the conversation on the 14th Amendment two things. So first, they're not trying to abrogate the Civil Rights Act. They are trying to constitutionalize its protections, right? So you have this big debate in the United States over, especially with regards to citizenship, whether Congress can just statutorily undo this, right? Whether that's sufficient, or whether they actually need to pass a constitutional amendment. And so they're not trying to abrogate it. They're trying to raise it to constitutional status.
Yes.
So why do they change the language, right? I think it's, again, clear throughout the debates that they're not trying to mean anything different by it. The change in the language comes almost entirely because they are actually trying to figure out how best, again, to exclude people. And in this case, it comes from very serious discussions about whether the Civil Rights Act language adequately made that distinction, created that same sort of allegiance distinction for certain types of tribally affiliated Native Americans.
Sure.
In essence, you had some people arguing, well, if it's just like Indians not taxed, you might have Native Americans, right, who have left their tribal affiliations,
right,
who have subjected themselves completely to the United. They've integrated. They don't consider themselves under this quasi, foreign jurisdiction of the Indian tribes. But if they're poor, they don't owe taxes,
right?
Or conversely, you might have Indian tribes who are, quote, subject to the jurisdiction of the United States. Well, because we give them millions of dollars and basically the army controls them, right? And so the argument is over how best to make that clarification for the Native Americans. But nobody really argues that it means something substantially different for the children of temporary residents. And in fact, not only are they trying to constitutionalize it, the Civil Rights Act definition. But you see repeatedly that when they're explaining what it means to be subject to the jurisdiction thereof, they mean quite literally the same thing. It's two sides of the same coin, right? These are complementary, not conflicting definitions. And to give you just one example of this, so you've got a quote from Senator Reverdy Johnson of Maryland. And he's explaining during these debates in participating in this conversation about how do we define it under the 14th Amendment that we're trying to draft right now. And he says this, all that this amendment, so this proposed 14th Amendment provides is that all persons born in the United States and not subject to some foreign power, for that no doubt is the meaning of the committee who have brought the matter to us,
boy, that's
shall be considered as citizens of the United States.
That's right? Pretty darn clear.
Right. They're sitting there going, it means the same thing.
Exactly.
Right? It's those memes where it's like two pictures.
Sure.
And it's like, they're the same thing.
That's exactly it. It's exactly
the same thing. And they repeatedly say this and indicate this. They're not abrogating it. And in fact, they mean it so much that after they pass the 14th Amendment, they repass verbatim the Civil Rights Act again in 1870. They reenact that.
Yes.
Right? They really meant it. They're not like, oops, maybe, no. They're like, we meant it, and now we're going to put it under the new Constitution as well. And those definitions, those two definitions, that statutory definition and that constitutional definition, they exist in tandem with the statutory definition being valid federal law for the next 70 years, 70.
Yeah.
Right. And when you look at how scholars and courts at the time understood that, they didn't understand it as abrogating or being in conflict. It's the same thing. It means the same thing.
So let me add another piece to this. Let me talk about a particular case that you and I mentioned briefly before the show. Funny name, but bears directly on what we're discussing. Right. 1898, the Wong Kim Ark case. What does that do for the argument that the framers never intended individuals who were here temporarily or did not owe allegiance, or did rather owe allegiance to other nations as legal citizens of those other nations, were never intended to be considered citizens? Yeah.
So I think a lot of people get Wong Kim Ark wrong, even what it was about in the first place.
So tell us, what was the case about?
So Wong Kim Ark is limited to a very narrow question. Okay, so you will have people say, well, the Supreme Court held there that birthright citizenship applies to all persons regardless of citizenship or immigration status of the parents.
Okay.
And it's simply not true. The court is very clear that they are addressing the status of the U.S.-born child of a specific and narrow subset of alien immigrants, basically. And it is those who are lawfully present and permanently domiciled. So let's talk about Wong Kim Ark's parents.
Yeah.
How do we get here? So Wong Kim Ark's parents come over to the United States in the early 1870s. Which at the time, immigration is essentially unrestricted. There's no way under the Constitution or under the statutes of the time, all the way up through that point in American history, for basically non-European immigrants to naturalize.
Yeah.
So his parents would not have had a way to naturalize, even in 1872. And then this gets worse under what are known as the Chinese Exclusion Acts in the 1880s. So his parents come here, they're merchants, they're domiciled here, they're living in the United States, working in the United States. And then in the 1880s, Congress passes a bunch of laws that do three things. They say explicitly that based on our treaties with China, Chinese subjects are perpetually Chinese subjects. They cannot expatriate, and they certainly cannot become citizens here. They are forever and always subjects of the Chinese emperor, no matter how long they live here. Two, they put a cap or a moratorium on immigration for Chinese laborers. And they define that very broadly. Doesn't matter whether it's skilled, unskilled. Chinese, quote, laborers are prevented from immigrating.
Okay.
And then under the Scott Acts later on, those Chinese laborers who were in the United States prior to this are told if you leave, you can't come back. Like if you leave even temporarily, you will not be readmitted into the United States. And Wong Kim Ark's parents are here, living in the United States this entire time. They're here for almost 20 years. They give birth to Wong Kim Ark, who was born here, raised here. At some point, like when he's 17, he goes back temporarily, comes back no problem because it's before the Scott Act. And then his parents, at some point in the early 1890s, leave. They go back to China. It's not clear to me from the historical record why. I can imagine why. Yeah. Right? They've essentially been told,
gotten very inhospitable in the United States.
So they're not allowed to become citizens. Right? They're being told you don't belong here. You can never belong here. Go home. And in California in particular, you're seeing a slew of very targeted and racist laws intentionally designed to run out Chinese businesses. Now, one more thing that I will note here is why it's important to note that his parents are merchants. Merchants were one of just a handful of categories that were universally understood as not being covered by the Exclusion Acts because they were not considered laborers, right? So his parents were of a category of lawfully present, permanently domiciled aliens who weren't even subject to other types of restrictions. Yeah. When they're here, basically their only restriction is that you can't naturalize. They are otherwise on completely equal footing with any other European immigrant that comes in here, except we say you can never become citizens in the way that the Europeans can. So his parents go back. Wong Kim Ark goes to visit them temporarily. He tries to come back in, and he's told, well, you're a laborer. We're not letting you in. Your parents might have been merchants, but you're not. And he goes, well, no, I'm a citizen. Right. Right. I was born here, raised here, subject here, right? I'm a citizen, even if my parents can't naturalize. And so that's what this fight is about. And the court says this. It says the question is whether the U.S.-born child of aliens who are permanently domiciled here, and they routinely emphasize their lawful status as well, that we allowed them to be here to the same degree, whether that person is a U.S. citizen, even if his parents could not naturalize. And the court says, yeah. And to an extent, like just logically, this makes sense, right? Congress had created a situation that was almost identical to the plight of the newly freedmen, right? After the Civil War, where under Dred Scott, we said, you live here, right? First of all, we forced you here. We forced you to come here. Right. You lived here, you died here, your kids live here and die here. Your kids live here and die here, but you're not citizens, right? Even though we can't say you're subject to some foreign power, like you're not citizens. That's essentially what we did to Wong Kim Ark and to Chinese immigrants who were here. We said, you can live here lawfully, permanently, for as long as you want. Your kids can be born here, live here, die here. You're not citizens. You can never be citizens, even if you're not born subject to any foreign power in any real, meaningful way. And we're doing this entirely because of your race. Yeah. That's exactly it. That's what the court is addressing. And the court, I think, actually gets this correct, gets the holding correct, that Wong Kim Ark is a citizen. Of course he is. Yeah. Like, you're going to say he can commit treason against the Chinese emperor that he was not born subject to. Right. He didn't live in that country. Right. If he were European, we would have been like, he's one of ours. We can draft him. Yeah. Right. Yeah. Right. Here's a musket. You're going to war, kid. That's right? Exactly it. That's what they're addressing. Now, there's language in that majority opinion that indicates that it's adopting common law just solely. Okay. Now, there's problems with this. One, to the extent it does that, I think it's wrong. Right? I think that's just factually not the correct understanding of the 14th Amendment. But I also think you can salvage this by understanding that that's not really even what the court like sort of says they're doing that, but they're not doing that. Because if they were, this opinion looks very differently. Like if this court were actually sitting there going, well, this is all about the adoption of English common law just solely. The opinion would just say, Wong Kim Ark was born here, physically, within the physical geographic confines of the United States. His parents were not foreign ambassadors or, accredited consuls or ministers. The end. Yeah. He's a citizen. I was just going to say. He's ours.
That's it.
Right? Things like lawful and permanent domicile are utterly irrelevant. His parents' status as being engaged in business, as being not laborers, subject to the Chinese Exclusion Acts, utterly irrelevant.
Yeah.
So the court, even in how it writes this opinion, even in saying, this is all about common law just solely, I think the best way of understanding that is they mean an Americanized version of that, at the very least.
Yes. And we've got all the history from 1866, from the periods of the framers of the 14th Amendment and what the language meant. We've got a series of very clear directives in the Congressional record. So then let me fast forward up to 1993, because I want to get to the executive order, because that really brings this entire debate home, and it puts a fine point on why suddenly it's become such a controversial issue. So Harry Reid in 1993 introduced the Immigration Stabilization Act, and that sought to do exactly what we were talking about, to restrict birthright citizenship by congressionally defining that term, which we see in the 14th Amendment Citizenship Clause, subject to the jurisdiction of the United States. So tell me a little bit about that bill, because what it really did was seek to eliminate any ambiguity going forward.
It was essentially Harry Reid saying, hey, Congress, can we seek to do exactly what Donald Trump right now is trying to do via the executive branch as a co-equal branch of government, which is to put a clear interpretation on this. Now, I think it's very clear that even as a co-equal branch of government, you can't statutorily just redefine a constitutional amendment to mean something more narrow, right? You can't say, for example, we've statutorily defined the right to keep and bear arms to mean, something other than to mean it's just a militia right.
That's it. That's it. That would be a dangerous ability.
Right. You can't statutorily define it contrary to the original public meaning. But what it shows at the very least there is Congress was looking at the executive branch actions over the prior decades and going, well, we think that's way broader than the Constitution actually requires. So we are going to, as a co-equal branch of government, tell you that it means this. And then had that been passed, right, they would have duked it out in court. The Supreme Court would have had to step in as the arbiter there to determine what it actually means, right? But it shows you that Congress at the time was seriously considering this.
And that the history has been misunderstood for so long, that this was an issue that they were wrestling with back in the early 90s as much as we're wrestling with it now in 2025.
Right. And that this has actually always been the case. So I might be jumping ahead here, because I suspect you might get into this question of whether this executive order is in this executive branch interpretation.
Yes, which seeks to do essentially in practice what the legislative body was trying to do via text.
I'll do you one more. It's actually seeking to do in practice what the executive branch did all throughout the decades immediately subsequent to the drafting and ratification of the 14th Amendment.
Yes.
Right. So you've got, you mentioned this lawsuit of mostly Democratic-controlled states.
So the executive order is titled Protecting the Meaning and Value of American Citizenship. Okay, so it moves to end so-called birthright citizenship practices. And the next day, attorneys general from 22 states immediately sued. Not surprising. Obviously, executive orders can be challenged in court. They are on a regular basis. I anticipate more, because more than 300 of them have already been issued under the current administration. And they've claimed that the president is attempting to eliminate a well-established and longstanding constitutional principle by executive fiat. We've just had a big conversation. So talk me through this lawsuit.
So, let's talk about the order first, right? So the order basically instructs other federal agencies.
Yeah, what's the practical application?
To not issue citizenship documentation. So things like passports, social security numbers, et cetera. To not issue those unless the U.S.-born child at the time of its birth had at least one parent who was either a citizen or a lawful permanent resident.
Okay.
And this is prospective, right? So it technically isn't into effect yet. So it as it's written, would only count for U.S.-born children seeking these documents who are born after, I think it's the end of February.
Okay.
Right. So it's not prospective. They're not trying to go back for generations and strip citizenship from people that we've told are citizens.
That's it.
So it's prospective. And it's about how the federal government is going to issue this documentation. And in this lawsuit, one of the arguments that the states make is, well, this is unprecedented. The executive branch has never done this.
Yeah. This is a great point.
I mean, that's only true if history starts in the 20th century. But unfortunately for them, that is not where history starts. So, and I document this in my law review article. You have in the 1880s, even up through the 1890s, right, getting into Wong Kim Ark territory, right? So decades of practice of executive branch decisions interpreting literally the same question. Who are we going to give passports to?
Yeah.
And you have multiple secretaries of state, multiple secretaries of the Treasury rendering decisions, instructing federal agencies not to issue passports to U.S.-born individuals for precisely the same reasons. So there's one from 1880 where the case is the U.S.-born child, this kid's born in Ohio. Everyone agrees is born in Ohio to German parents who, when the kid's like 2, they all go back to Germany. They pack up, bring him back to Germany. He's born and raised, he's born in the U.S., but raised in Germany to German parents who never declared their intent to become citizens, never tried to become citizens, never claimed to be citizens. And it is true, I think like 15 years later, his dad comes over and naturalizes. Okay. But at the time, they're like, we're Germans.
Yeah.
Right? And this U.S.-born, now young man who's raised in Germany, goes to get a U.S. passport. He says, give me a passport. I'm a U.S.-born citizen. And the Secretary of State says, no, do not give that man a passport. He was not born subject to the jurisdiction of the United States. He was born the subject of a foreign power. Don't do it. And you see similar things like 1890. You have a woman who is pregnant. She's an immigrant. She's trying to immigrate to the United States. She is on a ship in New York Harbor, waiting for the U.S. to decide whether or not they're going to let her in or not. And she goes into labor. They're not savages, right? So they bring her in. They let her give birth in a New York City hospital. Yeah. So now, not on a ship, but in the United States. This kid is born in the United States. And then ultimately they decide not to let this woman in, and they deport both her and the child. And she goes, well, my kid's a U.S. citizen.
Right.
My kid was born in the geographical confines when I was subject to the jurisdiction of the United States. And the Secretary of the Treasury says, nope, absolutely not. Right? And actually contrast that case with an earlier case where he notes the difference was in the earlier case where they did give the kid a passport, that woman hadn't been formally admitted yet, but they had allowed her, like she had resided for a significant period of time, not in the United States, not just she gave birth in the hospital, but she had resided here. She had been domiciled here, and that made the difference, right? That relationship, that allegiance, that inherent sort of connection to the United States was significantly greater.
Yeah.
Right? That is fundamentally the same argument that the Trump administration is making today.
Yeah.
And like to suggest that this has never before happened, again, you're not reading history.
It's disingenuous. It really is.
Exactly.
All right. So this is my last question, because I think we're going to hear a lot about this in the news. Mm-hmm. Not surprising. We saw, a flurry of legal activity toward the, issuance initially of the executive order. We've kind of talked about how it's going to play out practically. It's prospective only, not retrospective, right? So we're not going after individuals now whose citizenship has been recognized. Right. I think that's important to recognize. So here's my last question. We are going to put Amy's law review article, which is tremendous, in the show notes for this program so that you can link directly through and read it for yourself. It's got some great explanations of exactly why this is a constitutional executive order and really why the challenges should fail if you're looking at the history, the text, the tradition appropriately, as you should when you're reviewing the Constitution. Do you think a case like this, because it involves such a question of national importance and does have constitutional implications, is it destined for the Supreme Court?
I mean, it would seem to be.
Yeah.
I mean, you in theory could run into a case, right, where a circuit court strikes it down, and that the Supreme Court just doesn't.
Yeah.
It says that there's no circuit split here, and
Yeah.
we're just going to allow it to stand. Essentially, I would anticipate. I think more realistically, this ends with the Supreme Court weighing in on the original public meaning of what it means to be subject to the jurisdiction thereof.
Yeah, which would be much needed clarification.
And at the very least, it forces the nation's highest court which has a number of self-proclaimed originalists on it, to engage with that originalism. And that is something that you just have not seen done, I would say, one, by many advocates of universal birthright citizenship, but two, the flippancy of the judge in Washington who issued the initial injunction. Yeah. Where he issues, it's like a 2-page opinion where he just sort of rubber stamps it within 24 hours and just like summarily cites to Wong Kim Ark without explaining. Right. And as he's handing this out, he says very publicly and mockingly to everyone in that courtroom, he says, how could any member of the bar sit here with a straight face and tell me that this order is constitutional? Right? Like how can and if I get the last word, which I think you're going to give to me.
Oh, I sure am. I sure am. Don't you worry about it.
Because it's just sort of this mocking idea of like, where did you get your law degree? Like if you ever can even countenance this. Let me give you a quote here.
Please do.
This is going to sound, weirdly enough, very similar to everything I've said so far about like what I think the original public meaning is. Right. But this is not my own, right? So I might be giving this away too early here, right? So speaking of the 14th Amendment, this person writes, the jurisdiction must at the time be both actual and exclusive. So if a stranger or traveler passing through the country or temporarily residing here, but who has not himself been naturalized and who claims to owe no allegiance to our government has a child born here, and then goes out of the country with his father, such child is not a citizen of the United States because he was not subject to its jurisdiction. But the children born within the United States of permanently resident aliens who aren't diplomatic agents or otherwise within the accepted classes, which would seem to include illegal aliens, are citizens. And this is true even when the parents are of a race of persons such as the Chinese who cannot acquire citizenship for themselves through naturalization. Sounds weirdly similar to everything I've just said. Right? Yeah. Do you want to know who wrote that?
I think you're going to tell me.
Henry Campbell Black. That is the Mr. Black of Black's Law Dictionary. The same law dictionary that both the judge in this case and every other judge, every other lawyer, every other law student,
lawyer, and every one of us has to buy a copy of this.
And has on our bookshelves, because you're right, we all had to buy this as law students.
That's it.
Right? That is what he wrote in his Handbook of American Constitutional Law. And do you want to know when he wrote this?
Tell me.
1910. So we're even talking after Wong Kim Ark here.
Right.
And
after ratification of the 14th Amendment, after the Civil Rights Act.
It's not just him.
Yeah.
You see this with him, but you also see this with, I'll just give you like one other example, right? Even up through the 1920s, you had William C. Robinson, who was for 20 years a professor of common law at Yale Law School, writing this exact same thing, understanding this exact same way. And in fact, even up through 1926, you see, again, another Yale Law Review. Yeah. You have a guy who, one of the first like real advocates of universal birthright citizenship that I can find, and he says, he admits two things. He admits, one, the Supreme Court in Wong Kim Ark did not hold beyond the fact that it applies to lawfully present and permanently domiciled aliens. Yeah. That it's limited. But he says, well, I think it should apply beyond that. But I also recognize that my opinion here is at odds with a number of the leading constitutional and international law scholars of the day. He's acknowledging in 1926, I'm in the minority, right? So how's that for a whole bunch of members of the bar? Yeah. Who have recognized... Who had this ridiculous opinion.
Amy, that is your mic drop quote. I think you have cemented the perspective of not only me, who knew very little about this particular issue before I started looking into it because of your writings, but also for the people who've been watching and listening to understand that, in fact, the executive order is constitutional. So thank you for bringing your wit to Case in Point. Thank you for coming on with me.
Thank you for letting me nerd out. Appreciate
And next
you.
episode with you is going to be the swear words episode.
Yeah, I would actually like to take a poll amongst your listeners. I think henceforth,
We'll set that up.
I won't like throw a complete coup here and just rename it. But I do think that anytime I'm on, it should be
the swear words.
The swear words segment.
Episode.
Yeah,
You got it.
swear,
We'll do it.
Swear time with swear words. Got it.
I love it. Thank you for joining us on Case in Point. We'll be right back. Well, that's it for this week's edition of Case in Point, the legal show for regular people. Find us on all your favorite podcast platforms, Apple, Spotify, Rumble. Follow us on X at Case in Point Pod, and share this show with friends and family of yours who could use a little law in their lives. But until then, friends, court is adjourned.